Good morning, everybody, and welcome to our third and final installment in our three-part webinar on liability management transactions. My name is Anthony Canale. I'm Covenant Review's Global Head of Research, and I'm joined by my colleague Scott Josefsberg, Covenant Review's U.S. Head of High Yield Research. Also, my colleague Feng, who's a Senior Director with the U.S. Leveraged Loans team and the author of our quarterly series on U.S. liability management transactions. And we're also joined by my colleague Mark Lightner, CreditSights Head of Special Situations Legal Research. Today, we also have a special guest, Dan Kamensky, who's founder of the Creditor Rights Coalition and co-director of the Altman-Paulson Initiative on Credit and Distressed Opportunities at NYU Stern, where he's also a professor. Thanks, Dan, for joining us today. In today's installment, we're going to be discussing double dips and other LMT structures, as well as some of the bankruptcy considerations that are involved in these concepts and structures. We're looking forward to hearing from Dan and Mark on these bankruptcy-related insights. Now, for those of you who missed our first two installments of our webinar on up-tiering and drop-down transactions, don't worry because those episodes are currently available on YouTube. You can find a brief summary of those episodes as well as a link to the YouTube sites on the CreditSights website. And finally, a little housekeeping. The slides for this presentation will be made available to our audience following the presentation. So let's kick things off with a brief recap of what we mean by liability transactions. What is a liability management transaction? As we mentioned in previous episodes, there's no formal definition. At Covenant Review, we generally considered an LMT to be a transaction by a distressed borrower or issuer that utilizes existing or amended contract terms to manage long-term corporate debt liabilities with creative out-of-court solutions. Now, obviously, this can significantly affect creditor rights, collateral pools, and recovery values as a capital structure moves around and shifts and different debt ends up leapfrogging other debt. So there's no formal definition. We have been tracking LMTs by year, and I'll throw that to Feng to give us a little color on this chart.
Yeah, we spoke about this in our last session, but in general, we are continuing to see liability management transactions at a pretty healthy pace. Depending on who you ask, some might see a slight downtick, some might see a slight uptick. I expect it to be a 2025 to result in more LMTs than last year. Though again, that's largely dependent on how you want to define what an LMT or LME is. I would highly recommend for those who have access to check out our quarterly LMT reports. We also just published last week on the state of the European LME market, which is slightly different, although largely the same in many ways as well. And there's some interesting insights in that report as well. So on both sides of the pond, we're seeing liability management becoming a increasingly important topic for not just investors, but lawyers as well as anyone who's interested in the market.
So, Scott, can you give us a walk through double dip and pari plus transactions?
Sure. Thanks, Tony. So double dip transactions are a little bit different than the up tiering and drop down transactions that we spoke about in the previous sessions, in that those other types of LMTs generally rely on subordinating the existing debt in some form to the new LMT debt. In a double dip transaction, the debt is, generally speaking, pari with the existing first lien debt, but the idea is to create two first lien claims on the same assets. So when we talked about up-tier transactions, we were talking about transactions that typically either payment or lien subordinate the existing debt so that the new up-tier debt will be either senior in right of payment or have a senior lien on the assets. And when we talked about drop-down transactions, we talked about structurally subordinating the existing debt. But that's not what happens in double-dip transactions. So typically what happens to create two claims is a non-obligor subsidiary, so non-guarantor, will incur some new debt, and that debt will be guaranteed by the existing obligor group, and the same collateral will be pledged on a first lien basis. And that guarantee and pledge of collateral creates the first debt. But what also happens is the non-obligor on-loans the proceeds of the new debt to the company in return for an intercompany note. And that intercompany note is also guaranteed by the existing guarantor group, and the same collateral is pledged to secure that intercompany note on a first lien basis. The intercompany note is pledged by the non-obligor to the new money lenders, and that creates the second dip. So it's the guarantees from the existing guarantor group on the one hand that creates the first dip, and the intercompany note on the other hand that creates the second dip. Some variations we've seen on this, pari plus is generally speaking where new money debt has a pari claim on the existing guarantor group, plus some other stuff that the existing guarantor group doesn't get. We've also seen triple dip variations as well. On the next slide, as we go into some of the enabling provisions and how this sort of gets done. So typically speaking, we're looking for secure debt capacity. The two different dips are papered as separate liabilities. So generally speaking, the existing guarantor group would have to have 2 times the secure debt capacity to incur both debts. There may be some variation on that depending on the specific terms of the credit agreement or indenture that we're looking at. Typically, credit agreements and indentures have permissions, carve-outs for intercompany debt. Those carve-outs, when properly drafted, would require that the intercompany debt would be subordinated, which would prevent them from being used for a double dip structure, but doesn't mean that the issuer can't do a double dip. It just means they'd have to look for independent capacity outside of those intercompany debt and liens carve-outs. Also, it's possible for a double dip to be structured using an unrestricted sub rather than a non-guarantor restricted sub. And for that to happen, we'd be looking at the requirements for designating or having an unrestricted subsidiary, where those requirements are properly drafted. The unrestricted subsidiary is typically prohibited from having debt that is recourse to the restricted group. If that language is present, it would prevent using an unrestricted subsidiary for structuring a double dip, but that's not an all deal. So it is possible that an unrestricted subsidiary could be the primary obligor on the double dip debt. And to put a little bit of a finer point on that, we'll look briefly at the at-home transaction to see how the sort of prototype double dip transaction that we all think about what was structured. So what at-home did was they made an exchange offer to holders of their unsecured bonds, and holders who participated in that exchange offer were also given the opportunity to participate in a new money deal. And the new money deal was the double dip. These were $200 million of privately placed notes. Now, the primary issuer of these privately placed notes was a new subsidiary called At Home Cayman. It was a Cayman subsidiary, and presumably the reason they made it a Cayman subsidiary is because foreign subsidiaries are not subject to the guarantee requirements. So the foreign subsidiary was a non-guarantor restricted sub. This foreign subsidiary issued $200 million of private placement notes, and those private placement notes were guaranteed by At Home and the existing obligor group on the existing first lien debt. And they guaranteed and pledged that collateral on a pari passu basis with the existing first lien debt. At Home on loan those $200 million of proceeds to At Home in return for the intercompany note. The intercompany note was an obligation of At Home and also guaranteed by the existing guarantor group on a first lien basis. And the intercompany note was pledged in favor of the new private placement note holders. So again, the first step being the guarantees by the existing guarantor group, the second group being the first lien intercompany note that's pledged in favor of the new debt. So the result is, theoretically, there are 2 separate $200 million claims that those new money lenders could enforce against. And then on the next slide, Ian, can you talk to us about Sabre a little bit?
Yeah, absolutely. First thing I would mention, just to kind of follow on your point regarding how to calculate double dip sort of capacity, you're looking at things like debt and liens. In reality, trying to calculate actual double dip capacity is often a very difficult exercise, just because there's so many variants on how a double dip's going to work. Sometimes there's intercompany debt that's just permitted without limitation. That would certainly make things easier. But you're also looking at non-guarantor debt. If the proceeds of the intercompany note go to repaying debt at the existing group level, that could be credit agreement refinancing debt or refinancing debt. So it's often quite a difficult exercise trying to figure out what a company can do in terms of double dips, simply because there's so many ways of doing it. So the issue with Sabre is, there we go. So the issue with Sabre is it's not exactly a double dip because it's not two claims against the same assets. What Sabre demonstrates is the use of double dip technology in the form of the intercompany note. But the issuing entity was an unrestricted subsidiary, so different from at home. And two, it was getting the benefit of guarantees that were not providing the same level of credit support for the opco. So what ended up happening is you have two claims. One was from these foreign guarantors who were not providing credit support for the Sabre opco, hence the pari plus concept. And then you have a second claim via the intercompany note, similar to at home. So why is this important? Well, this really did start the trend of using double dips as sort of a component element to LMEs. We still see at-home type LMEs, but they often will be, nowadays, they're more likely to be a component of a broader LME construct. And a good example of that would be STG Logistics. So STG Logistics is sort of a great end case for us because it kind of adopts elements of all three of the major categories of LMEs that we've talked about thus far. It has a double dip, it has up-tier components, and it has a drop-down component. So STG, this is all from the STG Logistics ongoing litigation. This is as disclosed by the various complaints and responses from the parties in that litigation. But the way that transaction worked, according to the filings, was there was a drop-down component where the original STG entity transferred certain businesses to an unrestricted subsidiary. So that's your J.Crew element. That unrestricted subsidiary then issued three tiers of debt: a first lien first out, first lien second out, and first lien third out, all of which were structurally senior to the existing legacy debt. Ad hoc group members of the existing credit facilities then exchanged into these new tiers of debt at the unsub, a la up-tiering, right? You have ad hoc group coming into a first lien first out, as well as first lien second out, while non-ad hoc group lenders were primarily second and third out. And then you have a double dip. The unsub, the unrestricted subsidiary, took the proceeds of certain new money at the unsub financing level, and then loan those proceeds back to STG Logistics, thereby creating the second dip. So you have the double dip component here as well. You have STG, the original borrower, guaranteeing the debt of the unsub financing, a la at home. And at the same time, you have the pari passu secured intercompany loan, creating the so-called second dip. And STG is not sui generis. It is not unique. We have certainly seen other examples of LMEs that utilize multiple components from all types of LME transactions. And it does show you just how messy things can get. So the market response to double dips has been much more muted than when compared to things like CERTA or J.Crew. For example, you don't hear too often the term at-home blocker or double dip blocker, for the most part because it's not something that new issue debt is really seeking out as lender or creditor protection. That doesn't mean that those things don't exist. There is something called a double dip or at-home blocker, and primarily it attacks the intercompany loan aspect of the double dip structure. So the provision that we've started to see is there will be a global override stating that intercompany debt, if it's debt owed to a non-guarantor, either restricted or unrestricted subsidiary, cannot be pari passu secured. And that does put a pretty fine point on it. It blocks that second claim, right? You cannot have two claims against the same assets because you can't have that intercompany note being secured on a pari passu basis. Alternatively, sometimes you'll see double dip blockers try to get at a more substantive prohibition by stating that particular debt cannot be issued if it were to give rise to multiple claims on the same debt. Um, that's a little less common, although you'll see that as well. The primary issue here, of course, is low uptake. This is just not something you're going to see in new issue in either the broadly syndicated loan or high yield market. It does appear occasionally in private credit, and of course, it does appear in post LME credits, where the ad hoc group, of course, is negotiating better protections for themselves going forward. Are there other ways to limit double dips? Yes. Unrestricted subsidiaries is another aspect that you can attack if you're a lender or creditor and you want protection against a double dip. And that's to prevent the unrestricted subsidiary from essentially incurring debt that is recourse to the existing restricted group. Again, that would limit the ability to have that second claim against the original loan parties or obligors. Similarly, you can also just limit investments capacity, especially if the double dip utilizes some sort of pari plus component where you're trying to move additional value into that non-guarantor in order for it to have additional credit support, as illustrated by Sabre and SDG Logistics. Mark and Dan, I think this is the exciting stuff that we get to talk about now is how is a double dip going to be treated in bankruptcy?
Thanks, Ian, and hopefully you can hear me. If I see a thumbs up from Ian, I'll know that everything is working on my side. All right, great. So what we're going to talk about is the overlay of bankruptcy and a little bit of the hysterics of who is involved in each of these cases in terms of who is really incentivized to challenge the double dip structure. But there is real precedent here, and I think it is interesting to see how these have been treated in bankruptcy. I was involved in both of these cases, so I do have a bit of insight to how they played out. And I don't think we've really seen a double dip challenge in the current LME world in a bankruptcy case. And I think largely that it has to do with who was incentivized to challenge it. And I think we've seen it come up, I think, in At Home. The UCC initially brought it up, and then there was a settlement. So this is really hopefully a bit of a model of how it could play out if there really was a party incentivized to challenge. So the two cases and General Motors, Nova Scotia. So Lehman Brothers raised debt out of a special purpose entity called Treasury Co. BV. And that entity on-lent the proceeds to the parent company. So this is your prototypical double dip situation because the creditors would have a claim against Treasury Co. BV, which would have a claim against the parent company, and Lehman Brothers also guaranteed those. So this gave the creditors of Treasury Co. BV potential to recover 2 times their underlying claim, in contrast to other unsecured creditors of Lehman Brothers Holdings who would only have one claim. Given the setup of the case, holding company creditors were significantly incentivized to challenge that double because it essentially was going to dilute their recovery fairly significantly. And the challenge that was most effective in the case of Lehman Brothers was the challenge of substantive consolidation. Substantive consolidation is a theory that has gone through, I would call it a pendulum. In the early 2000s, it was used in an operating company case called Kmart, overturned by the Seventh Circuit. The Second Circuit has weighed in on this issue, and it's generally viewed as a very, very high standard where there's significant commingling and creditors are relying on the corporate structure as a whole and extending credit. Those types of facts are rarely present. However, when they are present, they are extremely important. And where I've seen that in my career has been mostly in financials because of the way that they finance themselves and in the case of fraud. So I think if you have those types of fact patterns and you have a double dip involved, I think that the theory of substantive consolidation can be used to collapse the entity. And if they collapse the entity, it wouldn't affect the collateral that was pledged. It would just affect the quantum of the claim that they're entitled to. Still be an effective tool with respect to challenging the double dip transaction that occurred as part of an LMT. The other aspect of Lehman I think that's really important and I think misunderstood is that the settlement in that case provided those creditors with a claim of 1.65 times. So there was significant risk built into the settlement of that claim. The reason why I think there's some confusion is that if you look at the plan, the intercompany claim is allowed in the full amount of $34 billion, but it's classified as an affiliate claim. And that was part of the negotiation in terms of giving the Treasury Co-BV creditors the appearance of having their claim allowed in full, but also acknowledging the fact that they weren't going to receive. That was entirely on account of the risk associated with that double. The second case with General Motors Nova Scotia, which very similar type of structure. There are some differences, which I'll explain, where General Motors had a Canadian finance entity which issued $1 billion of notes. Those notes were guaranteed by General Motors, and the finance entity was what was called an unlimited liability. Under Nova Scotia law, the unlimited liability company actually has a statutory claim on account of any deficiency against General Motors that would rank as a general unsecured claim. And there really wasn't any contention about the allowance of that intercompany claim. And the challenge in Nova Scotia was what's called the single satisfaction. And the single satisfaction rule is something we'll talk about in a moment, which is an equitable concept under state law that provides that creditors are only entitled to one recovery on account of their debt. So, for example, if the creditors extended credit on account of one debt, only where the single satisfaction has been addressed. And then the second type of claim that was in the background in General Motors is a claim under Section 502E1, which we'll also talk about in a second. In the case of General Motors, that claim was allowed at about 55% in terms of the total quantum of the claim that was potentially at issue. So if you look at the two examples in bankruptcy where it was litigated settlement, there was significant risk incorporated into the allowance of that intercompany claim. So if we go to the next slide, Mark and I will talk a little bit about what those potential claims are and some changes in case law that have happened since those early cases and what the potential risks are today. So Mark, you want to start us off here?
Yeah, Dan, before we do that, I mean, one of the overarching theories of the double dip, at least the way that I've thought about it over the years, and we'll get into this, I'm sure, is that it's really an element, it's credit support, right? And it's not a sure thing. And right, in these cases, oftentimes, even if they're litigated in the initial, right, they often settle at somewhere between 1 and 2 times. And the examples that you gave were at the upper end of that range. I mean, in your experience as someone who's been an investor over the years, is that really what like the goal is to give you like negotiating leverage? Because that's really what, ultimately bankruptcy is, right? We can talk about all the different legal theories and where those may ultimately come out, but it seems to me that's kind of my overarching principle, which is it sets you up for a really good, negotiated position in a bankruptcy. I don't know if you have thoughts on that viewpoint.
Yeah, I mean, I think that there are, in a lot of these, it's interesting because I'm going to talk a little bit about OID and office properties and trusts, and it's the same exact issue, which is how do creditors participating in these transactions enhance their recoveries at the expense of other creditors using all the various that are available. And so a double dip is a very effective strategy to do that, because if you're providing new money to a company as part of a exchange offer transaction, that new money provider is going to have the greatest amount of protection possible. The double dip allows them to do it. In the case of OPI, which we'll talk about, the extent you're trying to incentivize holders to exchange into a deal, allowing them to exchange to a higher principal amount is an effective tool to incentivize them to. So at the front end, it's about possession is 9/10 of the law. I'm going to do everything I can to protect my position and put myself in the best position possible, knowing, to your point, that there's risk down the road where I potentially might have to negotiate from a position of strength, but at least I'm going to start off with that potential enhancement.
Exactly. And that's, for what it's worth, I've always thought of the double dip as that tool, that hammer that gives you the best, position to negotiate from in a restructuring scenario. So in any event, we've thought a lot about different potential claims that can be brought to the double dip. A lot of really smart people in the restructuring community have given a lot of thought to these issues. So we certainly don't have the monopoly by any stretch of what these issues are. And a couple people have asked, has this issue been litigated in bankruptcy? And the answer is kind of. It's been litigated in various contexts, but in what I'll describe as the more intentional double dips, the at-homes of the world that we've seen in recent vintages, the answer is we don't have a definitive decision on it, so we can only extrapolate what case law exists out there to determine the strength of that negotiating position or what have you. But one of the legal theories that we've considered and a lot of people have talked about in the context of a double dip, which is whether that double dip is potentially a constructive fraudulent transfer. And for those of you that are not familiar with constructive fraudulent transfers, it's a type of avoidance action that allows a debtor or a trustee in bankruptcy or even a creditors committee that has standing to avoid a pre-petition transfer or the incurrence of an obligation or the creation of a lien that occurred in the pre-petition period, and allows value to come back into the estate. And there's all different kinds of flavors and permutations of fraudulent transfers. You have actual fraudulent transfers, you have constructive fraudulent transfers, and you have the ability to bring in various constructive fraudulent transfers under state law. We're not going to get into any of that. We actually have a webinar on fraudulent transfers specifically. Happy to share it with you if any of you want. But the basic legal theory here is that the debtor can unwind a transfer, which includes the creation of a lien, if it was done 2 years before the bankruptcy date and it gave the debtor less than reasonably equivalent value in exchange at a time when the debtor was insolvent. So in the context of a double dip, at the most basic level, we've got an opco situation that is given a guarantee, and we have the opco, which is also the obligor on the intercompany note. So in the example we used earlier in the discussion today, in that case, the operating company would be on the hook for $400 million, 200 on the guarantee and 200 on the intercompany loan. And in exchange, they only received $200 million in value. So you say, look, they are on the hook now for effectively $200 million in obligations, and they only received $200 million in value as a result of it. So on its face, you say, oh, well, that potentially could be, a constructive fraudulent transfer. You obviously have to prove insolvency or some other kind of distressed financial condition that's outlined in the bankruptcy code, and you say, look, that potentially could be a fraudulent transfer. But as Dan knows, and I know, and anyone who's ever practiced in bankruptcy, fraudulent transfer litigation is not for the faint of heart, because the facts and circumstances of these claims are extraordinarily complex. There's a lot of very smart, sophisticated lawyers in the restructuring community who spend their entire career litigating these kinds of issues. And so the facts and circumstances really come into play here. And as Ian mentioned, a lot of double dips incorporate all different kinds of other elements, right? It's very rare that you just have the ones, the at home. They're getting much more complex, and all of those different complexities, whether you're reducing your debt obligations as part of this structure is a really important fact, for example. So it's really going to depend on the facts and circumstances of the case. And as Dan knows well, there are other issues that may arise, such as the bankruptcy code safe harbor. So there's all kinds of nuances in this, but this is a potential theory that when this issue will eventually be teed up, would be ripe for decision. So super interesting. No real clarity, I think, on that specific issue. Dan, I don't know if you want to talk about. Yeah.
I'll make 2 comments on that, which is one, I think what's really interesting about it is that I think a lot of people don't even recognize that the theory applies because they think of fraudulent conveyance as a sale of assets. But to your point, the incurrence and the lien itself are a transfer that are subject to fraudulent conveyance. So that's the link. And that's why I think the theory is so interesting. Because to your point, well, if you're basically, not receiving anything in exchange for giving up twice the value, then that's potentially fraudulent conveyance. And then the second point is that, and Mark has sort of mentioned this, is that people will fight about what the benefits are. So, for example, if one of these is part of a larger transaction where runway is extended and there's a reasonable likelihood that the company's going to survive, that's a fairly strong defense in this context. but it is a real issue that we haven't seen really play out in a case that we could see at some point. I mentioned the single satisfaction rule. From my perspective, I've always felt that this rule is a real problem from the perspective of a double dip, because when I just think about the concept of a double dip and the concept of bankruptcy and the idea that you're only entitled to a single satisfaction, to me, those two concepts just seem entirely contradictory. And like I mentioned before, it played a pretty prominent role in GM negotiation. In 2010, a year after, the Second Circuit came down in the Delta case. And the Delta case didn't deal per se with the double dip. It dealt with a aircraft financing where you had a third party that was a equity provider into the SPD that had a guarantee claim. It's an intercompany claim to support the value of that equity contribution. And the court was determining whether or not the equity provider in that off-balance sheet structure was entitled to effectively two claims. That guarantee claim and the intercompany claim coming up with the SPD. And the court addressed the single satisfaction specifically and said that if Delta has contracted to pay duplicative claims, then it must pay both. It cannot repudiate its duty to party A under contract A by asserting that it contracted to pay the same amount to party B under contract. So you can see that this equitable concept running in the face of this idea of sophisticated parties being able to negotiate contract for a structure that's meant to give a credit enhancement to the third party. Now, that's the Second Circuit. That is not other circuit law. And this is ultimately, to me, a part of the pendulum of our courts looking at parties and situations as sophisticated people who need to negotiate. And we'll talk a little bit about Ancora. In that case, where the district court returned it on the basis that these are sophisticated parties who need to be able to look at contracts and negotiate, or are we more concerned about the relative position of creditors and capital structures, and we need to look at things from a more equitable perspective? So I don't think this issue is dead, the same way that I think subcon was dead. But I still think it's in the background. One other thing I'll mention about this is that Judge Jones from the Southern District of New York was at a conference 2 years ago, and really would think about analyzing a double dip. So I still think the issue is out there. The next challenge is something under the Bankruptcy Code, which is Section 502E1. So I'm going to make a little bit of a plug here for the Creditor Rights Coalition, my friends and partners from CreditSights, who are our partners. So we produce content. We had one of our contributors, Jim Millar, write on this issue in particular. Maybe we can share the link, but if you go to our website, creditorcoalition.org, under the Contributors tab, pull up his long-form piece on this. Jim is also the same attorney who brought up the Trust Indenture Act claims, Caesar's case, and he's the one who's challenging the co-op agreement to select us. So Jim, I think, has got a good track record on thinking a little bit outside the box. In short, what this rule does, if we go back, can I go back to the slide? Okay. So in the case of General Motors, okay, let's assume there was no intercompany claim, okay, but the issuer in that case paid off those notes. Well, under state law, the entity there, GM Nova Scotia, would have a reimbursement claim against General and the guarantee, or in this case, the bonds that were issued. And what the Supreme Court says is that you cannot get a reimbursement claim. You can't, by virtue of the fact that you're paying off a creditor, get the benefit of a contingent claim against, in this case, General Motors. That's disallowed under that section. The question is, does that concept apply to a double dip? Now, on its face, key difference between a double dip and what a reimbursement claim is that a reimbursement claim is contingent. It only rises upon the fact that, in this case, GM Nova Scotia made a payment on fund. An intercompany note is an obligation that's been incurred that is not contingent. So the argument is that that intercompany really was never intended to be a fully enforceable claim, which I think is a difficult argument. But again, it is a real argument. In the case of GM Nova Scotia, it played a more prominent role because the intercompany claim in that case was on account of a statutory claim. But can it be read into the broader context of a double dip? I think it's a very tough argument. but certainly one that can be made under. So there are other aspects of challenges in bankruptcy that we'll just quickly hit on here. So validation I mentioned before in the case of Lehman Brothers. Do you want to hit on recharacterization and equitable coordination?
Yeah, one of the theories that we've heard in the market is that you could potentially recharacterize the intercompany loan as a dividend. And bankruptcy courts are courts of equity, and they have the power to do this under existing case law if certain factors are present. And the court looks oftentimes at a bunch of different factors that are very frankly hard to establish. And it's just a claim that is often thrown out there, recharacterization of debt as equity as a potential tool in your negotiating toolkit, really, at the end of the day, in my experience, is what that is. So I don't think it's a particularly strong argument. And there's a number of factors the courts would look at to determine whether, in fact, the issuing entity was actually making a dividend as opposed to an intercompany loan for that double dip. And then the last idea is equitable subordination. There's a provision in the bankruptcy code that allows, similarly, a court to subordinate a creditor's claim to existing creditors under certain circumstances. And usually those circumstances involve conduct on the part of the creditor that was untoward, that was inappropriate and the like. And, this may be a very difficult argument in the context of double dips because the creditors oftentimes aren't the ones doing the thing here that people are complaining about. It's actually the borrower is the entity that's setting up the structure. So that kind of claim may actually not have a lot of legs, but it's definitely a claim that would be considered if this were squarely presented in a bankruptcy context. So as Dan mentioned, I completely agree with him that the concepts of substantive consolidation, characterization, and equitable subordination, which all kind of flow from equity, would probably be pretty difficult to establish in a challenge, but they nonetheless, I fully would expect them to be presented. So Ian, I don't know if you want to take it here, and then we'll talk about some of the
Yeah.
interesting legal issues going forward.
So this is our last session, and we did spend about 40 minutes talking about double dips, but we also wanted to talk about where do we go from here in terms of the broader LMT practice. We're talking about what is it going to look like in 6 months with liability management? How are things going to look in terms of not just how things are drafted, but the legal landscape? And we'll start with more on the contractual side, because that's what I'm comfortable with, even though I guess I am a lawyer. I'm talking about, like, what is it in the contracts that, one, allow for liability management, and two, what's going to happen to these provisions as time goes on? The way I think of liability management is it's a set of tools within existing debt documentation. And you can think of the kinds of tools available to sponsors and borrowers and issuers as falling into two primary buckets. There are those coercive tactics that are permitted by the existing debt documentation. And then I think far more interesting, and where I think a lot of the movement is today, are provisions that try to control the process of liability management. So these are the provisions that get put into new issue debt with no real thought as to having a liability management transaction in the near term, but the sponsor or the borrower wants to put those provisions into the document to give them the greatest amount of control for any future distress situation. Coercive tactics are a lot more simple in ways in terms of trying to understand them. They're really the sticks in a liability management negotiation. They are the ways that you get people to agree to your terms, and that can be in the form of economic sticks, either shutting off interest, which is something we've seen a couple of times, or stripping collateral, or stripping covenant protection. Those are all things that we see consistently and often when it comes to liability management. Vote rigging, I think we'll talk about in a little bit, but that's another element of a lot of these liability management transactions, even post Ancora. to take a step back, vote rigging is a feature, or not really a feature, but a tool that a lot of sponsors and borrowers use in order to change the underlying debt document to allow for a particular transaction. And in order to get to that change, you need to get certain members of your existing creditor group to agree to that change. And under most amendment provisions in both bonds and loans, you need a particular threshold of creditor support. So in loans, it's typically we call it rec lenders or required lenders, and it's a majority. Now, if you can't quite get there, what you can sometimes do as a company is to issue debt and then get to that level, because you're issuing debt from certain friendly creditors. Think of it in terms of if you have a revolver, for example, and that revolver consists of relationship banks. Those revolving lenders can promise to increase the amount of commitments available under that revolver to the point where the lenders who are willing to make a change to the document now account for a majority of lenders after you account for that increase to the revolver. So that's vote rigging. And there's challenges to that concept, of course. But for the most part, credit agreements and indentures do not actively prohibit such maneuvering. And the same is true for most of these coercive tactics. These are provisions that are essentially typical for new issue debt, both bonds and loans, and often because they are features of the underlying debt document. They do not allow for that documents do not actively prohibit such actions from the company. Process control is, again, much more interesting. Process control is a lot more interesting because it's what people are talking about today, and that's your anti-cooperation provisions, your lawyer-on-lawyer violence provisions. These are the things that are getting attention from reporters as well as from lawyers in general, and that's because they seem very new, and that's because they are. Anti-cooperation is in reference to a provision that has started to appear in some debt documents that essentially prohibits creditors from organizing. This first came about in Europe, where it was roundly rejected. It was roundly rejected in the US as well, but it's cleared in at least one instance that we are aware of, which is Warner Brothers' Discovery exchange offer earlier this summer. There is, of course, a vociferous response to anti-cooperation provisions from the buy side, which is they don't like it, and they've been mostly successful in rejecting anti-cooperation. Of course, from a borrower's perspective, having your thumb on whether or not lenders can even organize is a major strength in terms of what you can try to negotiate in the future. Lawyer-on-lawyer violence is very similar. This was something that was reported on over the summer. Functionally, it's a prohibition against lenders engaging specific creditor-side firms. And that could be law firms, advisory firms. We say lawyer-on-lawyer violence, but really it's any advisor. And that can be, of course, a major issue if you're trying to not just organize, but even find the right law firm to represent your interests as a creditor. There's a couple of major names out there right now who represent creditors for the most part, and having a provision in your document that says you can't actually hire them would be pretty problematic. The other three elements here, I'm not going to talk about in detail, but they're designed to control who's in your syndicate. So if you're the company and you know there are certain firms you don't want to be in your syndicate, there are ways to either kick them out or to prevent them from obtaining an interest in your debt in the first place. And let's move on to the legal landscape now. So Dan, I think you and Mark have some interesting insights here.
Mark, want to start us off?
Yeah, Dan, I'll start us off. There's a lot of legal issues that are on the horizon that we collectively are looking at. But I'm going to start with SCOTUS, not because SCOTUS is currently hearing the arguments in the IEEPA tariff litigation literally as we speak, but because it's really important, and there's several cases that are currently under consideration by the Supreme Court for potential cert grants, and we wanted to identify two for for this webinar because they potentially have impacts on liability management transactions. The first is the ongoing saga from Hertz. And the issue in that case is whether the debtor is required to pay a make-whole premium to unsecured creditors. And in that case, the lower court held that notwithstanding that make-whole premium would be disallowed as unmatured interest, that make-whole or those bondholders would still be entitled to post-petition interest because in that case, Hertz was solvent. Originally, when this case went up to the Supreme Court earlier this year, we thought that it was unlikely that the Supreme Court would grant cert on that, in part because the Fifth Circuit in Ultra Petroleum and the Ninth Circuit in PG&E were in congruence with the Third Circuit, so there was no circuit split. But in each of those lower court cases, they all split 2-1 in favor of the results reached by Hertz. And over very powerful, what I'll say, conservative dissents by judges in each of those circuits. So this went up to the Supreme Court, and the Supreme Court asked the Solicitor General to weigh in. And so we are waiting for the Solicitor General to weigh in on whether the Supreme Court should take that case. We have that request was put out by the court in June. It's now November. We're hoping that comes in any day now so that the court can consider whether to grant cert on that petition by the end of the year, and potentially we could have, if they do grant cert, a decision by June. The government shutdown potentially complicates that issue and may delay the filing of that brief, so it's very much a TBD at this point. The other case that we're watching that we think is potentially interesting, although I think it's unlikely or highly unlikely that the court would take it, but this relates to the Fifth Circuit's decision in CERTA. As many people at this point know, the Fifth Circuit issued a very important decision on the CERTA bankruptcy on December 31st of 2024, on New Year's Eve last year. We subsequently had a webinar. Ian was on that. We had Judge Peck was also on it. It was a great webinar. And the market at the time was very enamored with the open market purchase issue that the Fifth Circuit decided. But as Ian would remember, one of the things that Judge Peck and I talked about, that the lasting impression of that decision may be what the Fifth Circuit did with respect to certain other issues in the case, including that the court effectively took a veto pen to certain provisions of the plan of reorganization and struck through certain provisions and certain indemnities given to what we call the prevailing lenders in that case. So effectively, the Fifth Circuit went in and amended the plan on their own and didn't give creditors the opportunity to re-vote. And so that issue is currently before the Supreme Court, and the Supreme Court is going to consider that petition this Friday. So we may have a decision either Friday afternoon or on Monday morning when they issue the order list about whether the Supreme Court will consider that issue. So that potentially in the bankruptcy world could be a really important decision if the court takes that case. I don't think they will because it's not a big issue at the moment, and I don't believe there are a number of circuits that have split on that issue. So we'll wait and see, but that's definitely something that we're keeping our eye on. So I'll turn it over to Dan. I think he wants to tackle vote rigging.
For a case was decided in front of Judge Isger in a multi-month litigation, very factual based. And the background in Ancora was that essentially the company issued debt to the inside creditors to get over a voting threshold. And Judge Isger relied on the contractual language that said if the effect of the action is to subordinate the lien, then it's going to violate the contract. So he relied on this effect provision and essentially saying that these transactions are all connected, and so you couldn't look at them sequentially and different. And I look at this a little bit in the context of what I said before. These are ultimately courts of equity, even though he's relying on the contract. At the same time, we have very sophisticated parties who are negotiating these contracts. So this decision went up to the district court, and even though Isger had a very factually driven record or relied on the contract, the district court essentially said it has not issued an opinion. We don't know what it says in the opinion, but I'm going to summarize and said these were very sophisticated people. They were able to structure a transaction sequentially. You have to respect their right to contract. And so effectively signaled to the parties who's going to overturn the decision. So we haven't yet seen the written decision. I think that Ancora itself was probably limited to its own facts, even the way it was decided below. We will have the viewing course. We'll look at these transactions. The other big areas that are going to play themselves out in connection with talking about liability management transactions is really about whether or not the idea that in a liability management transaction you can have an inside group and an outside group who essentially are going to preserve value for themselves at the expense of it. So in the liability management transaction, the idea that it can be non-pro rata has been a development since CERTA that has really driven, I think, a lot of prevalence in terms of these transactions. Well, how does that play out in banks? And I think we have, a couple of different courts that have looked at the issue, and there's two that we're going to mention now. And we also want to give context here for where there are issues and where there aren't. The bankruptcy is very different than looking at a contract. If there's flexibility in the contract, what the waiver provisions are, amendment provisions. In bankruptcy, we have this come up conflict at the front end of the bankruptcy when it comes to DIP financing, and at the end of the bankruptcy when we're talking about exit. And you actually have two different standards that apply in those cases. And in the case of a DIP financing, the bankruptcy code has specific provisions about the ability to raise post-petition financing on a secured basis and providing adequate protection to pre-petition lenders. There is nothing in the bankruptcy code that requires there to be equal treatment at the time of that financing. Sometimes the issue arises because the bankruptcy code says that you have to provide adequate protection or receive the consent of the client lenders. What does consent mean in that context? And in cases where the administrative agent goes out to the required lenders, 50%, to get their consent to the priming of their lien. Well, does that then mean that the contract, pre-petition contract, governs not just consent, but how those pre-petition parties should be treated by the DIPs? And I think Mark will comment on that in a second, because I think there is some even dispute about whether or not the pre-petition contract should govern in that way. But it is worth mentioning that because we might see this more. Because if you think about it, the market has responded in many ways by inserting blockers into their credit agreements to prohibit many of the types of transactions that have been talked about in the webinar. And in particular, the CERTA blocker would prohibit there to be a in its simplest form, a non-pro rata super senior financing that wasn't offered in its simplest form. Now, those provisions ultimately are only as good as their drafting, but that is the concept. And so if there is a DIP financing, and if the DIP financing provides for a non-pro rata type of DIP financing, doesn't implicate CERTA. And so we do have Judge Goldblatt's view on that, which is worth mentioning, because in the context of having a pre-petition LME, if you're coming into bankruptcy, right, are the parties going to be incentivized to have continued non-pro rata transactions, especially in the context of a DIP financing? What Judge Goldblatt basically said was, look, in the first instance, if you look at a CERTA blocker, most of them actually have an exception for a DIP financing. So you don't need to offer the DIP financing to all of the different creditors. That's actually a fairly common exclusion. But what he did say was that the roll-up, the non-pro rata of the pre-petition debt, because it was non-pro rata, fell outside, or potentially fell outside of that exception allowing for DIP. So the parties in the market may well respond to that and expand that exception so that roll-ups are allowed, but it is really worth mentioning in the context of these not. Mark, anything there?
Yeah, no, I think your explanation of the issue is frankly spot on. And you're absolutely right that Section 364 of the Bankruptcy Code, which is the provision that authorizes a debtor with court approval to obtain secured financing, doesn't provide a necessary overlay, or doesn't really speak to the issue about pro rata treatment with respect to potential creditors. And so I think the way you teed this up and Judge Goldblatt's observations are very astute. And we'll just have to see where this plays out. And you're going to talk about Converge One in a second. It's a potentially completely different framework how we think about this when we're actually dealing with a statutory provision that provides a different result.
I would just add that from a market perspective, there has been no response to American Tire for the most part. We've seen a couple of instances where they've tried to address that issue, especially on the post-LME basis, but new debt, no. It's just carving out dips in general, just like it has before.
Interesting. So Converge One is a district court opinion that recently came out, I believe in October, where the district court overturned the confirmation of the Converge One plan on the basis that the backstop rights offering was only offered a subset of credit. And what he did was he relied on the confirmation standard, which is a letter that says that equally situated creditors must be treated similarly. Now, that provision is one that, on its face, would seem to have a lot of real bite to it. And the reason why it has rarely had an effect in bankruptcy cases is that creditors have successfully argued that when they're given this exclusive right to backstop a rights offering, or they're given the exclusive right to provide a direct placement on the exit financing, or receive premiums or fees that aren't offered to other holders, that it's not being provided to them on account of their claim. It's being provided to them on account of that opportunity that they're providing. And courts have generally been very sympathetic to those arguments. And in the case of Judge Hannon, instead, he said, look, we've just heard from the Fifth Circuit CERTA, read the first sentence in that opinion. They're talking about how sacrosanct the concept of pro rata is. And when I think about that, it tells me that I need to inform my view of 1123 by saying that any rights here have to be provided to all creditors under the bankruptcy. Now, one other comment I'll make about this is I don't believe that his decision is in a vacuum, because there actually has been some very significant academic writing in the area. Vince Piccola has written something called The Backstop Party, and that is I think a seminal piece, and I think a lot of the judges are familiar with it, where he's analyzed the amount of value that creditors have obtained on exit financing opportunities, compared it to what the market would pay them for that. And what he's concluded is that the only way to explain the discrepancy, meaning that parties are able to exert excess market leverage against issuers, is to say that they're doing it on account of their claim and their ability to vote in favor. And so that academic writing supports this thesis even further. So I wouldn't be surprised to see that that this becomes a bigger issue going forward. So I know we're coming up on the end here, so I can hit the last two issues fairly quickly. And again, these are going to be significant upcoming issues. It's too bad we don't have more time to talk about them, but I will tee it up. Ian spoke about the co-op agreements and how issuers contractually are trying to limit it. Well, we've now seen the first challenge to a co-op agreement in connection with LME litigation. And to me, what's interesting is that you have a non-pro rata deal, and the co-op agreement said that certain creditors were excluded from participating in that transaction. And the challenge here is being brought by some of the excluded creditors. And actually, I'm going to let you, Mark, I know you don't like to play an antitrust lawyer, but I think you do know antitrust pretty well about this. And so just give your view on what you've talked about, because I do think it's pretty compelling.
Yeah, no, look, I mean, this is an issue that frankly I've thought about for years with respect to co-op agreements. And it's very interesting to see how this is going to play out. But and again, I'm not an antitrust lawyer, although sometimes I do play one on TV. There's a doctrine in antitrust, which is if horizontal competitors agree amongst themselves to restrict competition, that is per se unlawful under the antitrust laws. And so, if you consider the market float of a particular, issuer or security as a market in and of itself, you've got different competitors or bidders of those securities, locking themselves up to exclude competition amongst others. And so I've always kind of had this kind of, scratching my head. I'm like, is that an antitrust violation? And I know people in the market, lawyers, smart lawyers have, raised this issue, but it's never really come forward. So this is, at least to me, very interesting to see where this plays out. But by contrast, and Dan and I talked about this yesterday, that's exactly what we do in bankruptcy, right? So you create this kind of weird world where what we're doing now, is inappropriate, but yet when you get into bankruptcy, it's all about negotiations and creating groups and and agreeing with each other. Super interesting. That was just filed in the last week, and just like the office properties trust case, these issues are alive and well. So
Yeah, and the thing to me that's really interesting about Selecta, that it wasn't totally apparent, is that there's actually very different arguments that excluded creditors are making versus, call it, sponsor slash debtor side that are making. And I think it's a really important distinction to just focus on, which is excluded creditors aren't saying in that case that co-op agreements are per se unlawful. What they're saying is that the anti-competitive behavior is excluding parties from. So the remedy there would be to actually allow all of the creditors into the co-op. And to me, that seemed like the right result. And it's actually a result that actually would work against issuers who are trying to prohibit co-ops together. So to me, if the result in this, and again, we don't know how it will play out, is that ultimately co-ops are open to all creditors, that to me would be a significant benefit to the market versus having co-ops knocked out altogether. And I think it's a real important nuance in terms of that litigation that I hope will play itself out. So the last issue here, to me, is an oldie but goodie, and it's original issue discount, make holds, and whether or not they're enforceable in bankruptcy. And the reason why this has just been teed up is that Office Properties and Trust filed for bankruptcy 4 days ago, and in the bankruptcy filed 2 days later an adversary proceeding seeking to disallow original issue discount. So why is this important? In the context of an exchange offer and in the context of it, if a company is exchanging old debt for new debt, and the value of the old debt is lower than the face amount of the new debt, that will generate a light. And there are complex rules that accountants use to measure the value of the old debt to determine if OID is issued. But many exchange offers will generate OID. And OID is an accounting concept that an issuer has to effectively amortize that discount. But in the context of bankruptcy, the problem is that OID may be considered unmatured interest, which is disallowed under bank. Now, you really have OID come up in two different contexts. You have it come up in the primary market. Oftentimes, bonds are issued at a discount, and you have it come up in exchange. And in the primary market, if you're looking at a bankruptcy case, you own a bond issued with OID, secured bond, there's no doubt in anyone's mind that that original issue discount will be considered to be unmatured interest. But if it's generated by an exchange offer, it's a very different analysis. And what the code doesn't say is the code doesn't say that original issue discount is disallowed. It says that unmatured interest. So OID is not necessarily unmatured interest. And this issue has come up in 3 cases. I'm involved in the most recent one, and every court has rejected the application of OID to an exchange offer. And we talk about the Hertz case, where in the context of a make whole, the Fifth Circuit said, even though it's unmatured interest, it's still payable because it's solvent. And if we're talking about secured creditors, there's an additional provision in the bankruptcy code that protects them. So ultimately, I feel fairly strongly that this issue will be decided in favor of their claim, and that the debtors will lose and have to pay out. So, Ian, that's sort of my last issue on the page here. If you want to open it up to any questions.
Well, we are running over time, but I'm happy to answer anything quick. There's a couple of good questions that we can answer quickly. One is did First Brands, because everyone loves First Brands, was that an LME? And the answer is generally no. It did not utilize any LME strategies, in part because I think it happened too quickly. They just didn't have time to do a LME type transaction. And there was another question about whether companies can trade derivatives if they are blocked, like activist investors. And the answer is, in general, yes, but it depends on whether they are also holders of the debt of the term loan or bond. So there is something called net short disenfranchisement that's common in both high yield and in term loan debt. In that, if you're a term loan lender of record and you also hold a net short position in CDS, you're actually not allowed to vote on matters under the credit agreement. So that is a good question.
Well, I'd like to take this opportunity to thank Dan, Mark, Ian, and Scott for participating in today's webinar episode and for participating in the series as a whole. And thanks to all of you in our audience for attending our liability management transactions webinar series. As I mentioned earlier, recordings of the entire webinar series are going to be available on YouTube, and the slides will be available also to our audience after this presentation. I want to thank you all again for attending, and look forward to speaking with you soon. Thank you.